Very good morning. This is Professor Dr. M.R.K. Prasad, V.M. Salgaonkar College of Law, Panaji, Goa. We are now looking at scheduled caste, scheduled tribes and other backward classes and access to justice. The brief structure of this presentation: first we would be looking at understanding certain key concepts like what is caste, what is Varna, who is SCs, who are STs and who are backward classes. And thereafter we would be looking at the status of these backward classes before commencement of the constitution and what kind of safeguards were made pre-constitution regarding the rights of the depressed class. Thereafter we will be looking at the status of this depressed class after the constitution, and then we will also look into what special legislations were passed for the purpose of protection of these vulnerable groups. And then we will look into the commissions that were appointed to monitor the effective implementation of the constitutional safeguards to the vulnerable groups. So, this is how today's presentation will go. So, before starting with that, we need to understand certain key concepts. The concept that the fundamental purpose of law is to secure equality. If there is a need for the growth in the society, and all social groups must have an equal access to such growth and such opportunities. But the concept of justice could never be the same for all the people living in different layers of the society. So, the people who are in the higher class, people who are in the lower class, the concept of justice cannot be the same, because the victimization of the people differs depending upon not only their economic status, but also their social status in the society. What I mean is that the violations of the rights of the people differs if you are in a higher status in the society, and it would be different if you are in a lower status in a society. So, because of this, you cannot provide justice to the marginalized communities the same as the dominant communities in the society. So, therefore, the groups like the scheduled caste, which we generally call as Dalits, and the scheduled tribes, whom we are addressing as Adivasis, and the other backward classes, they were historically disadvantaged, vulnerable, and they are socially oppressed. Therefore, they require a special protection. Mere giving an equal status to all of them would not be sufficient, because the level of exploitation, the level of vulnerability, the level of disadvantage of these people are different from the dominant communities. So, therefore, we need to understand certain concepts like Varna. Now, this picture shows the 4 classes of Varna. Varna was divided into 4 classes. On the top layer we have Brahmins, the second layer is the Kshatriyas, the third layer is Vaishyas, and the fourth one is Shudras. Now, the Varna has a hierarchy. What I mean by hierarchy is there is a fixed slots. The Brahmins are always on the top slot. The Brahmins are basically the priestly class. The second status in the society is given to the Kshatriyas, who are the warriors, kings, rulers, governors, etc. And the third position was given to the Vaishyas, basically the farmers, merchants and craftspeople. And the last layer in the Varna system is the Shudras. The Shudras are the farm workers, servants and the laborers. So, the Varna system was mentioned as old as the Rigveda, where the Rigveda says that these Varnas are creation from Brahma. So, according to Rigveda, the 4 categories are come from Brahma, that is the main man or the Purush we call in Sanskrit. The Brahmins comes from the mouth of Brahma. They are the priestly class, teachers and the preachers. The Kshatriyas are coming from the arms of the Brahma. They are the kings, rulers, warriors as we discussed earlier. The Vaishyas comes from thighs, mostly merchants, traders, artisans, and Shudras are coming from the feet of Brahma. They are laborers and service providers. So, this is the origin of Varnas. But we need to understand Varna because there are certain misconceptions that we have by equating caste with Varna system. So, therefore, if you look at the characteristic features of Varna, Varna is immutable. What I mean Varna is immutable means in the hierarchy always the Brahmins are top. Second comes the warriors, that is the Kshatriyas, and the third is the Vaishyas, and fourth is Shudras. And no given point of time Shudras can be first or second or third. So, the slots are fixed and they cannot be interchangeable. But unlike caste, Varna is not hereditary. Varna is determined by the virtue. What is the virtue here? Any individual with his merit can move to one Varna to another Varna. That means, if a person who is born to a Shudra's father can become a Brahmin by his virtue, his knowledge, his merit. So, therefore, originally the Varna division was based on individual temperament, their aptitude and quality. So, what is your Varna is decided by your quality rather than your birth. That means, if a person has a higher quality can become a Brahmin. If a person has the qualities of warrior, he becomes a Kshatriya. If a person has the qualities of merchants, peasant, then he becomes Vaishya. So, that means the Varna system advocates the virtue rather than the birth. However, when it comes to the caste is different from Varna. Though caste could be attributed to Varna and most of the time mistakenly used as a synonym to Varna, but it is not the same. Caste is a group having two characteristics. One is the membership of the caste is confined to those who was born as members, and it also includes all the persons who are born to that particular persons. And the second one, usually the members are forbidden by a social law to marry outside the group. That means, once you born to a particular caste, you have to marry another person from your own caste, but not outside the caste. So, like Varna, caste system also creates a hierarchy. This hierarchy is created by placing certain castes higher than the other caste in a social structure. But unlike Varna, caste hierarchy in Indian society is decided on the basis of purity and pollution principle. That means, the occupations which were thought as pure would be having the higher status, occupations having pollution, that is polluting occupants are treated as lower caste, and sometimes they are treated as untouchables. So, the scheduled caste being polluting occupations becomes untouchable. So, if you look at the difference between Varna and caste, Varna is decided by the virtue, whereas caste is decided by birth. Second one, Varna is immutable, as we already discussed. Brahmins are always top and followed by the Kshatriya, then Vaishyas and Shudras, whereas caste is mutable. That means, a particular caste which is higher in the strata in a particular society may not be this higher strata in another community. That means, a particular caste which is higher caste in state of Andhra Pradesh, not necessarily a higher caste in Karnataka. So, therefore, the caste hierarchy is mutable, different from region to region and place to place. And another most important difference is in Varna, a person could change his Varna by virtue, by increasing his capacities and capabilities. However, such a thing is not possible in a caste. Caste cannot be changed, as caste comes by birth. So, with this brief background, let us look into the scheduled caste. Now, when it comes to scheduled caste, though there is no specific definition who is a scheduled caste, generally a scheduled caste means an indigenous group of people who are known as untouchables. That means all untouchable caste comes under scheduled caste. So, the term such as Shudra and Dalits were used in synonyms to the scheduled caste. They are historically disadvantaged and discriminated. Therefore, to uplift them, Gandhi, instead of calling them as scheduled caste, he used to call them as Harijans, which means children of God. The Simon Commission is the first one who coined this term scheduled caste in 1935. So, the same expression was adopted by the Constitution in 1950. So, to define scheduled caste, Dr. Majumdar describes the scheduled caste as those who suffer various social, political disabilities, many of which are traditionally prescribed and socially enforced by the higher caste. So, they are socially, economically, educationally, politically are backward. Then the scheduled tribes, which we sometimes call as Adivasis, they are the second largest group of the backward class of the underprivileged. They have traditionally lived in hilly areas. The legal term designated to them as social tribes are actually the aborigines who still adhere to their own tribal customs. So, they have three fundamental characteristics to become a scheduled tribe. The first one is the primitive way of living. Second one is nomadic in habit, that means they may not have a permanent place, they will have nomadic in nature, and habitation in remote and inaccessible areas. Usually these are the three characteristics, but may not be necessarily that all should be fulfilled to be declared as scheduled tribes. So, Majumdar again gives a long characteristics of scheduled tribes, which amounts to collection of families or groups of families bearing a common name, occupy the same territory, speak the same language, and observe certain taboos regarding marriage, profession or occupation, developed as well as assessed system of reciprocity and mutuality of obligation. These are some of the characteristics. Similarly, in the Imperial Gazette of India describes a tribe is a collection of families bearing a common name, speaking common dialect, occupying or professing to occupy a common territory, and is not usually endogamous through originally, though it may be originally have been so. That means originally it may be endogamous, but not anymore. So, when it comes to the backward class, there is no definition, and usually the backward classes are consisting of economically, socially and educationally backward. If you look at the Indian Constitution, there is no definition given for either SCs or STs or OBCs, that is other backward classes. It simply says that or the Constitution simply authorizes the President of India to appoint a commission to determine who are the SCs, STs and OBCs in India. If you look at the pre-constitutional position regarding the status of these people, the caste panchayats during the pre-colonial period are the predominant, and they decide the status of the backward class. So, during the colonial period, the British introduced a uniform legal system to curb these disadvantages, and as a result, the powers of the caste panchayat was given to civil courts. They are transferred to the civil courts. So, for example, earlier the caste panchayats would be talking about marriage, divorce, etc. Now that becomes the powers of the courts, and the caste panchayats are no more having such powers. The examples that you could see is the Caste Disability Removal Act, the Special Marriage Act, the Hindu Widow Remarriage Act, etc. And what is the impact of these acts? They try to remove the disabilities associated with the caste, trying to avoid untouchability and and legalized the inter-caste marriages and inter-religious marriages. It permitted the remarriage of the widows, and in addition to that, there are several social reforms and reform movements were initiated by the progressive Indian citizens to remove these caste disabilities during this time. And as a result, several reforms were carried out by the British. However, if you deeply look into this, what happened during those days, though British brought several acts to curb these disabilities, they have no desire to reduce the rigidity of the caste system. So when India became independent and a new constitution was written, the constitution has the daunting task of removing these inequalities. So therefore, the removal of caste disabilities completely fell on the constitution, and the constitution used 3 strategies to remove these disabilities. First one is protection. Under the protection, if you look into the constitution, particularly the fundamental rights, they bring equality under 14 and also specifically prohibits discrimination on the basis of caste. And the second strategy that the constitution used is providing a compensatory discrimination. That means provide a special provisions. That means one side you talk about equality and prohibit the discrimination on the basis of caste, but at the same time, based on the caste and backwardness, the constitution tried to provide special provisions such as reservations in educational institutions, reservations in public employment, reservations in political institutions, etc. And the third strategy that the constitution used is the development. That means allocation of certain resources and distribution of benefits to the scheduled caste and scheduled tribes under the constitution. So these are the 3-pronged approach the constitution used for the purpose of protecting the rights of the backward classes. So if you analyze the constitution, the promise of social justice in the preamble reflects in its provisions. There are social safeguards were given under Article 14, which talks about equality before law. Article 17 prohibits untouchability. Article 25 clause 2 subclause B says that Hindu religions or institutions of public character shall be open to all Hindus. That means it prohibits the Hindu institutions restricting the entry of Dalits. And Article 46, the directive principles of state policy, says that the state has to promote educational economic interest of weaker sections of the people, in particularly scheduled caste and scheduled tribes. Similarly, Article 366 talks about the scheduled caste and scheduled tribes, and in addition to that, Article 341, 342 also talks about identification of scheduled caste and scheduled tribes. So these are the social safeguards that the constitution provides. When it comes to economic safeguards, Article 23 prohibits trafficking, begar and forced labor. And historically, if you see that the prostitution, that is the human trafficking, or selling the people, buying the people, or prostitution, or forcing the people to work for less wages, bonded labor system, most of them are belonging to the scheduled caste. So therefore, Article 23 prohibits or protects the economic safeguard for the vulnerable groups. Similarly, 16 clause 4 provides reservations in appointments of public employment to the to the backward classes, SCs and STs. And similarly, Article 335 says that the state empowered to make relaxation of qualifying marks for the backward classes, the SCs and STs, in the examination. Now the educational safeguards, 15 clause 4 provides special provision for the advancement of socially and educationally backward. That means you can get reservations for SCs and STs and OBCs in educational institutions. And Article 29 clause 2 prohibits discrimination in admission of any educational institutions on the basis of caste. Therefore, SCs or STs or other backward classes cannot be denied any admission into educational institutions. Article 350 talks about adequate facilities for instruction in mother tongue, and Article 46 again talks about promotion of economic and educational interest of the SCs and STs. The political safeguards that we have is that Article 164 talks about every state to have a minister in charge of tribal welfare and also be in charge of welfare of the scheduled caste and backward classes. Article 330 reserves reservations for the seats in Lok Sabha. 332 talks about reservations in Vidhan Sabha. 243D and T talks about reservations in Panchayat and municipalities. Article 275 clause 1 talks about specific allocation of funds for promotion of welfare of the scheduled caste and scheduled tribe. And Article 338 and Article 341, 342 also provides several benefits for the social and educationally backward SCs, STs. Then in addition to that, Article 32 and 226 gives protection to the fundamental rights and the constitutional rights, and also the Supreme Court in Bandhu Mukti Morcha says that the scheduled caste and scheduled tribes can seek a quick remedy under Article 32 and 226 when their fundamental rights are violated. When it comes to the legislative protection, there are several legislations that were passed in addition to the constitution to protect the rights of the deprived class. Worth mentioning is the Untouchability Offences Act 1955. This act was passed in 1955, which rechristened in 1976 as a Civil Protection of Civil Rights Act, and this act prohibits untouchability and makes the untouchability as an offence. This was passed in accordance with Article 17 of the Constitution. What are the major offences under this act is enforcing religious disabilities from entering into a public place or worshipping place on the grounds of untouchability. Similarly, you cannot enforce social disability regarding access to the shops, hotels and places of public entertainment. And also you cannot refuse to admit the people to the hospitals or refuse to sell the goods, insult the people, abuse the people or any other behavior, or unlawfully or compulsorily make these people to work for the purpose of scavenging, sweeping, removing of the carcasses and any other such jobs. And the act also provides punishment for all these offences. The offences under this act is punishable from minimum 1 month to 6 months imprisonment and a fine from minimum 100 rupees to 500 rupees. The second legislation that was made for the purpose of protection is the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act in 1989. This act was passed when the state realized that the prevention of the Protection of Civil Rights Act is not sufficient in addressing the issues of the scheduled caste and scheduled tribe. This act was passed, and this was passed to enable the SCs and STs to live in dignity. So this act establishes a special court for the trial of any offences under the SC/STs Atrocities Act, and this act also talks about rehabilitation of the victims. So the practice of untouchability is made both cognizable and non-cognizable offence under this act, and the act lists really 22 offences relating to various behaviours that would destroy the self-respect of SCs and STs, and only the precondition is that you need to establish a strong evidence that the victim was a member of scheduled caste or a scheduled tribe community. And the another feature of this act is that only non-SC or non-ST member would be liable under the act. That means if an offence is committed by an SC member against another SC or ST member against another ST, it is not covered by this act. It is covering only if a non-SC against SC, non-ST against ST has committed the offence under this act is covered. So the offences under this act could be tried only, could be investigated only by the police officer, not the below the rank of the Deputy Superintendent of Police. That shows the seriousness of the state in curbing these atrocities. Now the trial of these offences under this act could be done only before a special court, and such special court need to be headed by the sessions judge, and the state has to appoint a special prosecutor for this act. In Gangula Ashok and others versus State of Andhra Pradesh, the Supreme Court held that it is mandatory that to send these cases under the SC's Prevention of Atrocities Act to the magistrate court first to observe the committal procedure. So that means the procedure before the judicial magistrate has to take place before going to the special court. So let us look into this procedure. The special public officer or public prosecutor appointed by the state and the defense advocate will present their arguments before the judicial magistrate to commit the case. So if the court rejects that the charges framed by the police, then the court will close the case and the accused will be discharged. But if the court is under the impression that there is a prima facie case exists, then the court will take the cognizance, frame the charges and post these cases for the trial before the special court. And the trial before the special court is same as that will be followed in the general criminal courts. However, the most important or notable feature of this act is that the mens rea is not an essential ingredient to constitute a crime under this act. The another legislative protection that we have is Safai Karmacharis Act 1993. This prohibits manually carrying human excreta or any sanitation work. So this is a very important piece of legislation because it is actually affects the dignity of the human beings, forcing them to work in sanitation work. Then in addition to that, recently in 2013, the central government has brought another piece of legislation, that is the Prohibition of Employment as Manual Scavengers and their Rehabilitation Act 2013. This prohibits the employment as a manual scavengers. It also talks about rehabilitation of manual scavengers and their families. Then the state under this act can confer the executive magistrate the powers of a judicial magistrate of first class. This is for the purpose of a trial of offences under this act. That means any person who committed an offence under this act would be tried before the executive magistrate, and the executive magistrate would exercise the powers of judicial magistrate first class. And the executive magistrate will be deemed for the purpose of the Code of Criminal Procedure Code as a judicial magistrate first class. The offences under this act would be tried summarily, and offences under this act are cognizable and non-bailable. So in addition to this, there are commissions that were appointed for the purpose of protection of the rights of the scheduled castes, scheduled tribes and backward classes. The National Commission for Scheduled Castes and Scheduled Tribes was intended to safeguard the interest of SCs and STs. The commission receives the complaints and investigates the matters that comes to its attention through newspapers or any other means. That means the commission actually start working not necessarily only on the complaint received from somebody, but even on the reports of the newspapers and media. And the important point is that the commission has the powers of civil court. However, this commission was subsequently divided and made into a separate commissions for SCs and STs, because one commission is not in a position to effectively deal with the problems of SCs and STs. Therefore, now they have a separate National Commission for Scheduled Caste and there is a separate National Commission for Scheduled Tribes. Similarly, a National Commission is also established for the backward classes in 1993 in response to the Mandal Commission case judgment. So this National Commission for the backward class will be looking into the inclusion, exclusion of backward classes in certain caste groups into the backward class or not. So on a whole, all these national commissions would be looking into the conditions of the SCs, STs and backward classes, who would be included, who would be excluded from that, and monitoring the government schemes and welfare programs, whether they are reaching to the scheduled caste, scheduled tribes and backward classes. In addition to that, each state also established their own commissions for the backward classes and the SCs and STs, because for the purpose of the central government they have a separate list of SCs and STs and backward classes, and the state can either follow the central list or they can identify their own list. So, therefore, there are several attempts were made to protect the interest of the backward classes, SCs and STs. Thank you.